Hello boys and girls. So I hope you are doing very good. So this video may I would like to analyze CA Inter Corporate and Other Laws May 2025 paper. So I would like to give you the suggested answers for that particular question paper. So let us quickly go through how the question paper was. So if I have to give you a simple analysis, sir, question paper was very easy. Leaving 2-3 questions, Hannah, I don't think students should find any difficulty in solving this particular paper. In fact, MCQs to were dead easy except one MCQ. So let us try to check them, sir. So as we know, sir, part 1 is MCQ. We have 15 MCQs and each MCQ carry for 2 marks. So scenario based question was given. What I have observed was, even if you don't look at this entire para, still you will be able to give the answers. So to save the time, I would directly jump to the questions. So Classical Diagnostic Limited proposed for a variation in shareholders voting right. How much percentage of issued shares of that class shall be required for consent for passing such resolution? So I just highlighted the key word here. So here company wants to vary the shareholders voting rights. So can I say, if a company wants to vary the shareholders voting right, for that we have a provision in section number 48 which talks about variation of shareholders right. So whenever company wants to vary the shareholders right, obviously we are talking about class shareholders. So class shareholders are nothing but your preference shareholders. You have various varieties, 8%, 10%, 12%. So these are all class shareholders. So here company ka proposal is to vary what, sir? Their voting rights. Okay, very good, sir. Is this allowed? Answer is yes, sir. To do this, consent is required of not less than 3/4 of the issued shares of that class. So in other words, we are talking about what, sir? 3/4 of the members should give approval. That is nothing but passing special resolution, sir. So here, what was the option, sir? A was talking about at least 51%, B 66%, shareholders of at least 71%, holders of at least 75% of the issued shares of that class. So can I say, as per section 48, so this is the answer. D is the proper answer, sir. Okay, now can I say 75% of issued shares of that class are going to pass the resolution by SR, sir. Now there could be some dissenting shareholders also. So now let us talk about that particular point, sir. Second point, where the holders of at least dash of the issued shares of the class who did not consent to or vote in favor of resolution. So that is what we are talking about, sir. So imagine if 75% has approved, so can agreed, so can I say 25% has dissented, sir. So dash people who did not consent in favor, sir, may apply to whom? Tribunal to have a variation cancelled. So in other words, they want this variation to be cancelled. So how much percentage of the members has to agree for that? So if at all we see section 48, again we will be finding this particular answer, sir. Subsection 2, where the holders of not less than 10% of the issued shares of a class did not consent to such variation or vote in favor of the special resolution, they may apply to the tribunal to have variation cancelled. So here the MCQ was with respect to how much percentage? So answer is 10%. So can I say second bit is also from section 48. Okay, so answer is 10%. Great. Next, let us talk about third point, sir. Bharosa Insurance Company Limited has issued certain instruments, very good, which among the following shall not be covered under the definition of securities. So what is not regarded as a security is what we have to talk about, sir. So can I say definitions are given in section number 2 of Companies Act. And if at all we want to see securities definition, it is given in section 2 clause 81. And you will be seeing that it is not defining exactly the term, it is just giving a reference to another section, sir. Let's see section 2 clause 81. Securities means securities as defined in clause H of section 2 of Securities Contract Regulation Act 1956. So in other words, they are saying, Bhaiya, we don't know the definition, you go and refer section 2 clause H of SCARA, that is Security Contract Regulation Act. So let us also see what is Security Contract Regulation Act talking all about, sir. So I'll just show you the SCARA Act here, and in that, let us see section 2 clause H. Yeah. So here, obviously detailedly so we will not discuss, sir. Just try to see what are the things included. Securities include shares are there, scrips are there, stock, bonds, debenture stock, and other marketable securities. Derivatives are also there. Units of collective investment scheme is also there. Security receipt as defined in SARFAESI Act is also there. Units of mutual fund is there. Government securities are there. Such other instruments as may be declared by central government to be securities are also there. And rights or interest in securities are also there. So these are all the parts which are covered in the definition of securities. So now let's come back to our main question. So what will not be regarded as securities? So we have to find out the odd ones. Now, can I say bonds is a security? Already we have seen debenture is also a security. Preference share is also a security. Now, obvious logic is unit linked insurance plan was not regarded as securities. There we have seen units of mutual funds, not unit linked insurance plan. So hence D is the right answer, sir. Now, so what we have observed here, even if we did not read the entire scenario, sir, we were able to give the answer. Okay, now let us see scenario number 2. Here also you can follow the same approach. Now scenario 2 may the question was with respect to FEMA. So entire question was with respect to FEMA. Dr. Ronak Mose has inquired from you that for which of the following purposes is he allowed to draw foreign exchange. That means for which purposes foreign exchange can be drawn. Draw is nothing but utilized, sir. Now, sir, if you want to travel to Nepal, for that, can you draw foreign exchange? Answer is no. Can I say this answer we can get from our FEMA? So FEMA may we have something called current account transactions and capital account transactions. So if at all we see schedule number 1 read with rule number 3, you will be finding list of all current account transactions which are prohibited. In other words, PRI cannot carry out this type of transactions, or PRI cannot use foreign exchange for doing this type of transactions. Draw of foreign exchange for these transactions are not allowed. Usme first list what you can observe is transaction with Nepal or Bhutan. So payment for travel to Nepal or Bhutan is prohibited. So in other words, can Mr. Ronak, Dr. Ronak use foreign exchange for this purpose? Answer is no, prohibited, sir. Remittance of $50,000 out of lottery winnings. Again, if you see here also, you will be finding what, sir? This is also a prohibited transaction, sir. So you can see remittances out of income from lottery winning is also prohibited. So this is also covered in schedule number 1. So this is also prohibited, not allowed. Remittance for purchase of sweepstakes. So can I say it is a sort of gambling? Even this is also not allowed, sir. Remittance for purchase of football, sweepstakes, this is also prohibited. So in other words, if you can observe, all these three were nothing but schedule 1 read with rule number 3, and they were all current account transactions, and all these are prohibited. Now the only thing now left is what, sir? Gift of $10,000 to his brother in Canada. Obviously gift is also a current account transaction, and if at all we observe, sir, there is something called schedule number 5, schedule number 3, rule number 5. Okay, so rule number 5 may you will be finding there are list of transactions which are allowed for a PRI. So can I say a PRI up to $2.5 lakhs, this is what we call as LRS, liberalized remittance scheme, sir. Up to 2.5 lakh $1,000, sir, per financial year, he can use or he can draw for giving gift or donation, sir. So obviously draw of foreign exchange is only doing 10,000, sir. 2.5 lakh tak it is allowed. So hence this is the right answer, sir. And this answer we are giving as per schedule number 3 read with rule number 5. And this is also a current account transaction, sir. Now, Mr. Ronak Dr. Ronak desires to remit $1.5 lakhs as a payment of prize money to the winning team in a cricket tournament in Canada. He needs to obtain approval from which of the following? So in other words, they're asking you from which authority they have to take the approval. Now first point is, can you draw foreign exchange for this particular purposes? Answer is yes. So for this you will be seeing what, sir? There is something called schedule number 2. Now schedule 2 read with rule number 4. Now schedule 2 mein you will be seeing prize money for sports. Remittance of prize money or sponsorship of sports activity abroad exceeding $1 lakh requires approval, sir. In our case, you might be seeing, sir, it was $1.5 lakhs. Up to 1 lakh, approval was not required. But because they are going for a $1.5 lakhs, that is more than 1 lakh, sir, obviously approval is required. Now question is from which ministry? So here the ministry is Ministry of HRD, Department of Youth Affairs and Sports. So we have to find out which is that, sir. So no approval is required. No, this is wrong. Up to 1 lakh, no approval was required. Transaction is a prohibited transaction. No, it is not a prohibited transaction because it is not schedule 1 transaction. It is actually schedule 2 transaction, sir. So Ministry of HRD, Department of Youth Affairs and Sports. So this is the right answer, D. For his show in Canada, can I say this is nothing but a cultural tour we are talking about, sir. So can he draw the money, that is foreign exchange, for cultural tours? Answer is yes. So this you can see schedule number 2 mein, first point mein it is written. So for cultural tour, permission of Ministry of HRD in the Department of Education and Culture is required. So here let us see, Ministry of Finance, no. IB, no. CIT, no. So here HRD, Department of Education and Culture. So D is the right answer, sir. So can I say simple MCQs they were, sir. Now let us see MCQ from LLP chapter, sir. Now, so here also they have asked you some questions. Let us see what is the part, sir. Now here we have to see the scenario also, sir. Rohit and Anushka, can I say ICI, ये क्या कर दिया आपने? Can I say justice with Virat Kohli now? Now Rohit and Anushka, can I say Anushka? Sorry, okay. Rohit and Anushka, after passing out CA examination, they have incorporated an LLP to work as a practicing chartered accountants. Rohit and Anushka were also titled as designated partners. Yes, we know as per section 7, it is compulsory, mandatory, required for a LLP to have at least 2 designated partners, and in which one of them should be resident, sir. After some time, Rohit got an opportunity to provide consultancy services on an ongoing basis to a company based in Singapore. Okay, very good. Rohit remained in India for 90 days during the financial year 23-24. The LLP continues its operations from India with Anushka, whereas Rohit participates in decision making remotely. Remotely means not in India. Based on the facts given above case, and by applying the relevant provisions of LLP Act and the applicable rules therein, choose the correct answer for the following MCQ. Now can I say applicable rules therein? Now rules are not forming part of syllabus. Anyway, they wrote in the question, so no offense in that. As per LLP Act 2008, whether LLP fulfills the requirement of designated partner. Now, can I say designated partner ke liye, what is the rule, sir? As per section number 7, LLP should have at least 2 designated partners. In that 2, you can see section number 7, every LLP shall have at least 2 designated partners who are individuals, and at least one of them should be resident in India. So can I say, even though Mr. Rohit is working remotely, he is not a resident in India, so still that is allowed because Anushka is anywhere living in India only. So whether the LLP fulfills the requirements of designated partner? Answer is yes. Yes. Acha. C and D is also there. Let us see C and D. Yes, as Rohit is a resident of India. Answer is no. Can I say for resident of India criteria, the days are 120. So you can see here explanation is given. For the purposes of this section, the term resident in India means a person who stayed in India for a period of not less than 120 days during the financial year. So for the financial year 23-24, Rohit should stay in India for at least 120. He stayed only for 90. So he is not resident. But still, चलता है, not at all a problem. LLP is in compliance of section number 7. So C is a wrong option. Which is the right option, sir? D. Yes, at least one of the designated partners should be resident in India, and Anushka is resident of India. Section number 7. As per LLP Act, the term resident in India means a person who stayed in India for a period, obviously not less than 120 days, sir. Great. So these were 8 MCQs, very simple MCQs, sir. Now let us see ninth one. Now this is some MCQ. This is that type of an MCQ, sir, where student may find little difficulty, sir. Reason is numbers are involved, sir. Now anyway, General Clauses Act was enacted on 11th March 1897. Okay, great. To consolidate and extend the General Clauses Act dash and dash. Now here if you open your textbook, sir, first page mein you will be finding something called preamble. So in class when we were discussing, I did tell you General Clauses Act 1897 is not a new law. In other words, they were earlier other laws which were also dealing on this particular matter, sir. So you can see the history here. First was General Clauses Act 1868, then it was General Clauses Act 1887, then it was General Clauses Act 1897. So General Clauses Act 1897 ka preamble if you read, this is the preamble, sir. The General Clauses Act 1897 was enacted on 11th March 1897 to consolidate and extend the General Clauses Act 1868 and 1887. So 1887, 1868. So option number D is the right option, sir. Now you can also remember like this, 1897, can I say uska 10 is what you have to remember, 1887, and 1868 is nothing but 20 years back you are going, usme 1 year you have to deduct, sir. Anyway, so this was the time limit, sir. Now let us go more forward, sir. Or you can also remember Gandhi Jayanti, sir. Can I say Gandhi ji was born in 1869, 1 year less than that. So now let us talk about 10th point, sir. 10th MCQ. So 9th ka MCQ ka answer is D. So Jade Suits LLC, okay, is a chain of hotels and restaurants all over the world. So obviously they are talking about LLC here. It is proposing to establish a hotel in Goa, sir. Hotel at Goa. Very good. It has appointed a chartered accountant, Mr. B, for taking care of the registration formalities. While the registration process was ongoing, in other words, necessary filings were made, approval was pending, sir. The company entered into a lease agreement, wow, with the landowner for the construction of its hotel. After few months, obviously they should have not done this. Reason is, can I say all these transactions you can carry out once you obtain the registration, sir. After few months, the directors of Jade Suits LLC withdraw their interest in establishing a hotel at Goa due to news in social media regarding the fall in tourism industry. Very good. The landowner refused to repay the advance because already they have entered into a lease agreement, sir. Can Jade Suits LLC sue the landowner in the capacity of a foreign company? Oh. Means directly if they want to sue, that is second question. Whether they can sue in the capacity of a foreign company, sir. Can I say foreign company ke liye we have section 2 clause 42. What is a foreign company? That is not the question here. Whether they can sue this in the capacity of a foreign company. Obviously, Jade LLC is a company, company incorporated outside India, having business in India, sir. So obviously it is a foreign company. But can I say to do business transactions, registration is must. Did they do the registration? Answer is no. So again, is this allowed? Can they sue? Answer is no. So let's confirm this with our Companies Act provisions, sir. So as you might be knowing, sir, foreign company ka chapter is chapter number 22. It starts from section number 379 and it ends on 393A. So let us see what this chapter may it talks about, sir. So 393, last but one section, if at all you observe, any failure by a company to comply with the provisions of this chapter. So obviously registration was must, you did not register. Can I say for doing any transaction, first do the registration and then do the transaction. Here they entered into a lease agreement, still the registration process was pending, sir. Then, but the company shall not be entitled to bring any suit. In other words, you cannot file any suit on anyone, sir. So let us see what is the option given, sir. Jade Suits LLC is a foreign company. Can sue? Answer is no, they cannot sue, sir. Jade-Sue LLC is incorporated as a foreign company. No, it is yet to be incorporated. Registration process is not yet complete, and hence Jade-Sue LLC cannot sue the landowner in its capacity as a foreign company. Yes, so they cannot sue in the capacity of a foreign company. This is the right answer, sir, as per section 393, sir. Once the registration process has started, the company is deemed to be incorporated. Answer is no. Deeming provisions are not there, sir. So hence, which is a better option, sir? Option number C. And this we are giving answer as per section 393, sir. 11th bit, sir. An instrument in the form of depository receipt. Instrument in the form of a depository receipt created by domestic depository in India and authorized by company incorporated outside India, making an issue of such depository receipt is called as. Now can I say, for this we have to understand the provision, sir. So here what is happening, sir? Depository receipt is created by domestic depository in India and authorized by company incorporated outside India, sir. Then obviously they are in India, so obviously it is Indian depository receipts. Remember, Indian company, if they are issuing depository receipts outside India, then that could be GDR or ADR, depending upon the countries where they are issuing, sir. But because it is done by a company incorporated outside India and it is being issued in India, then obviously it should be nothing but IDR. Now, can I say, for this also we can refer the definition section, sir. So section 2 clause 48 defines what is IDR, Indian Depository Receipts. IDR means any instrument in the form of depository receipt created by a domestic depository in India authorized by a company outside India. So obviously the right answer is IDR. So here section 2 clause 48 is what we are referring to, sir. The term year as per General Clauses Act 1897 means. Now, can I say, what is it? General Clauses Act may, they have defined the word year also and financial year also. Focus is not on financial year, focus is on year. So we have section 3 clause 66 in General Clauses Act. So let us see what section 3 clause 66 has to say, sir. So you can see the definition. Year shall mean a year reckoned according to British calendar. In other words, year is nothing but British calendar, and British calendar starts from 1st January and ends on 31st December. Instead, still if you have any doubts, sir, now in our textbook only they have defined financial year, but there I say also has went one step ahead and they have also defined what is year. The term year has been defined under section 3 clause 66 as a year reckoned according to British calendar. Thus, as per General Clauses Act, year means calendar year which starts from January to December every year, sir. So here it is January to December. So this is year reckoned according to British calendar which starts from January to December, sir. So B is the right option, sir. Now again we have scenario 4, sir. Okay, so this is meetings chapter, sir. So again, here also what I have observed was, if you see the questions, you can easily give the answer, sir. So 13 points, sir. 13th MCQ. Mr. Rajan, a member of a company entitled to vote at the meeting of the company, shall be entitled to inspect the proxies lodged provided he has given. So here we are talking about proxy inspection. We are talking about inspection, sir. So Mr. Rajan is an existing member and he wants to exercise his right of inspecting the proxies. So can I say proxies ke liye we have section 105, and if you can recall the subsections, it is 105 subsection 8 which talks about inspection rights, sir. So let us see 105 subsection 8. So this is the benefit of reading through BERAC, sir. So if at all you approach or you follow this approach of studying from BERAC, thing will be what, sir? You need not put extra efforts in solving the MCQs. Otherwise, I have observed many students, they buy a separate book for MCQs, sir. Thing is not required. If your concepts are very clear, then can I say from whichever part they are asking, you will be always be able to answer. Now let us see 105 subsection 8. Every member entitled to vote at a meeting of a company or at any resolution to be moved thereat shall be entitled during the period beginning 24 hours before the time fixed for commencement of the meeting and ending with the conclusion of the meeting to inspect. So this is nothing but time limit for inspection, sir. When he can start the inspection? 24 hours before the commencement of meeting. And how long he can do inspection? Till the conclusion of that meeting, sir. But to do this, what he has to do? Provided means this right co, if you want to exercise, you are having one duty. What is that, sir? Not less than 3 days notice is given in writing of his intention to inspect, sir. So in other words, subsection 8 may two things you have to understand. One, you are having right of inspection, but if you want to exercise this right of inspection, you just cannot come in the meeting and say what? Show me the register, show me the proxy forms. Not allowed, sir. To exercise this right, you have to give prior notice to the company, and that prior notice should be given 3 days before the commencement of the meeting, sir. And you can start doing the inspection 24 hours before the start of the meeting till the conclusion of the meeting. Now let us see what they are talking about, sir. Not less than 24 hours notice to the company is given. Answer is no. 24 hours set, so you will start doing the inspection. So can I say this is where students can go wrong, sir? So A is the wrong answer. Not less than 3 days notice of the company is given in writing of to the company in writing of the intention so as to inspect the proxy log. Yes, this is the right option, sir. 2 days, 12 hours. This is completely wrong. So here 105 subsection 8 was tested, sir. As per company secretary of the company, advise the board of directors to reply on the question raised by a member in the meeting with respect to the prescribed period for which the company shall preserve the register of members. So for how many years we have to preserve the register of members and copies of document filed with ROC, sir. So can I say for this also we can refer the section, sir. So let us see section number 94, sir. Yeah, so let us see section number 94. So 94 is talking about place of keeping and inspection of registers. Isme, if at all you see subsection 1, and in that you can see is proviso 2, second proviso, sir. Provided further that the period for which the register, returns, records are required to be kept shall be such as may be prescribed. So in other words, this part is given in the rules. So let us also see the rules. Now anyway, we are having abundant time, not at all a problem. Rule number 3. So register of members, form number MGT 1. Or 8 minutes, sir. We are talking about maintenance. Yeah, so here we have rule number 15, which is dealing on this particular thing, sir. Obviously, remembering rule numbers will become a bit difficult, sir. So here directly section number with you can just, though it was asked as an MCQ, if at all it is asked in a theoretical manner, sir, it is always better to write the section number and then write what, sir, as the corresponding rules, or you can write the name of the rules, sir. Now, rule number 15 is what we are talking about. So if you can see here 15 sub rule number 1, the register of members along with the index shall be preserved permanently. So register of members MGT1 was the form number, sir. It has to be preserved permanently. And if you can see sub rule 3, copies of annual returns, these are the ones which are filed with ROC, sir. And copies of all certificates and documents required to be annexed thereto shall be preserved for a period of 8 years. So one is permanently, one is 8 years. So let us see what the options are. Can I say register of members के लिए we are having permanently, sir, and for copies of documents to be filed with ROC के लिए 8 years. So here C is the right option, sir. Now Let us see 15th point. Mr. Praveen has approached you to seek Mr. Praveen. Wow. Mr. Praveen has approached to seek guidance that for how many years he can accord his confirmation to act, for how many members, sorry sir, he can accord his confirmation to act as a proxy. Now just now we have seen proxy 105. Again they are asking question relating to proxy only, sir. Now if at all you observe, sir, max to max a person can be acting as a proxy for 50 members. So you cannot be proxy for more than 50 members. So let us see, this is 52, this is 52, this is 50, this is 50. So can I say 52 cancel? Now C and D could be the right option, sir. 50 members ko you can represent, but they should not hold more than 10%, sir. 10% of what? Total share capital carrying the voting rights. So can I say C is the right answer? And this you will be finding in section 105 also. And with this we conclude your MCQ part, sir. Now let us discuss theoretical part, sir. Now theory may I just made a short synopsis, sir. How many questions were asked? So totally 6 questions were asked. Question number 1 was compulsory. From 2 to 6 you were supposed to write any 5, sir. So out of 5 we were supposed to write any 4. So totally the question paper was for somewhere around 84 marks, sir. So let us try to go forward, sir. Now so question number 1, I will be a bit fast, sir. Now so Mr. Amrish, after completing his postgraduate in mechanical engineering from United Kingdom, he has returned to India. Okay, fair enough. Although he had a good placement in UK based company, but he thought to build his own reputation, own business empire in India. Sorry, very good. Amrish belongs to Rajasthan, where his parents are also having agricultural land. Up to here, complete nonsense. He planned to manufacture commercial drones. Very good. For this purpose, he planned to incorporate a company. Acha. So, in other words, the key word here is Amrish wants to incorporate a private company in India. Very, very important point is private company, sir. Sorry, very nice. Having the following persons as the first subscribers to the memorandum. Okay, so these people are the subscribers. So one is Mr. Amrish himself. He is a subscriber. Mr. Robert, who is a friend of Amrish. He is actually a citizen of UK, but he is visiting India on a valid business visa, sir. Okay, so obviously he did not come for any tourist, etc., sir. He came for business purpose in India, sir. Similarly, there is an Eliza. She is also a citizen of Netherlands, but she did not come to India, sir. So she is still in Netherlands only, sir. Then Goma Devi, she is mother of Amrish, but she is illiterate, sir. Okay, great. Then one more subscriber is LLP, and one more subscriber is Mohit Electronics Private Limited. So these people are all subscribers. So totally 6 subscribers are there. Private company ke liye to at least 2 was more than enough. Here 6 subscribers are there, sir. Sorry, let us see what is the question, sir. Amrish has planned to have registered office of the proposed company at Jaipur. Okay, let him open the company in Jaipur. Factory, etc. will be at some other place. For incorporation of a company, an application for registration is to be filed with the registrar. Correct? Hai? Spice Plus they have to file. In the given case, the initial subscribers to the company consist of 1 illiterate, correct? Hai? 2 foreign nationals are there, 1 LLP is there, 1 private company, and Amrish himself is also there, sir. Discuss the procedure, how these persons shall subscribe the memorandum of association and also the articles of association, sir. So here we have to tell them how this procedure, how they are going to do the subscription, sir. So for this we read section number 7 read with rule number 13, sir. Now rule 13 of which chapter, sir? Because 7 is incorporation of company, so obviously rule 13 will be the company's incorporation rules 2014. So for Amrish, what is the procedure, sir? So simple, sir. How he has to subscribe? Obviously he has to write his name, he has to write his occupation, he has to write his address, sir, and then he has to put the signature, sir. So you can see here he has to sign the MOA, AOA. He has to specify, that is nothing but mention his name, address, description and of occupation, if any, sir. And his signature has to be also be, what do you say, he should sign in front of another person also, sir. So that another person is testifying the fact that Amrish has signed in front of him, sir. So in other words, those people are called witnesses, sir. So witness should also be signing, sir. Now why witness is signing? He is attesting the signature. He is telling that Mr. Amrish has signed in front of me, sir. And he should also put his signature. He should also give his name, address, description of occupation, if any, and then he has to mention this line. What is the line, sir? I witness to the subscriber or subscribers who has or have subscribed and signed in my presence. He has to write the date and place. Further, I have verified his or their identity for their identification and satisfied myself of his or her or their identification particulars as filled in, sir. In other words, this line he has to mention, sir. By writing this, what he is telling to the total world, yes, I have seen this person has signed in front of me, I have seen his ID proof also, sir. So as a declaration he is giving to the total world, sir. So in other words, these are the formalities for subscription, sir. So first, Mr. Amrish, you should sign, you should mention some details, and then some witness should, what is it, attest your signature, sir. So this is what it is, and this is the manner, sir. And if at all you really wants to see that, that also I can show you, sir, how this particular thing looks like, sir. Better. So this is the memorandum. Now you can see here. So there is one person, some person is there, sir. So he is the subscriber. He has to put his signature. What is it? He has to write his name. He has to put his signature. He has to write his father's name. Also, he has to give address details. Date of birth actually is not required, though he wrote business, if any. So this was if any, and then place and birth, sir. So number of shares he is taking, he also has to write. And then there should be somebody who should act as a witness, because this company was incorporated by me, sir. So I was acting as their witness, sir. So you can see this is the entire thing which they are specifying, sir. Now, this is a very old company which I have incorporated, sir. Now, as per the recent law, I will just show you one more company, sir. We are supposed to mention that particular line also. Again, I have opened the same thing. Yeah. Yeah, you can see here. So here also this was incorporated by me, sir. So he is the subscriber. Now you can see here, this is the line which I have written. I witness to the subscriber who have subscribed and signed in my presence. Further, I have verified their ID particulars of the both promoters and satisfied myself about their particulars. And then I have to put my signature, sir. So this line I have to write. So this is the manner of subscription, sir. I hope you have understood this line, sir. Okay, sorry, great. So this was for Mr. Amrish. Now there is Mr. Robert and there is Eliza. Now Robert is in India. Robert is in India, sir. So obviously, and that too, he is on a valid business visa. So what is the manner of subscription, sir? So same manner, sir. He also has to put his signature, sir, and specify his name, sir. And an Indian can witness this particular point, sir. But because Eliza is not in India, so can I say Indian witness is not possible, sir. A foreigner may, who has to do this witness? Now for that, answer differs. Now whether that country is in the Hague Convention or not in the Hague Convention, sir. Now because Netherlands country was specified, I did Google search, and what I observed was Netherlands is a party of Hague Convention, sir. So in other words, ऐसे situation में the witness signature has to be apostilled, sir. There is a concept called apostillization, sir. So here what will happen, sir? Can I say Eliza? She is going to sign the memorandum and articles. Very good. She is going to specify her name, address, description, sir. Then this document has to be taken to a notary public. That document has to be notarized, and afterwards it has to be apostillized, sir. Now maybe some students may have confusion with respect to apostillization, sir. So this was one company where we did apostillization, sir. So that's the reason I thought I will better open this, sir. So this is notary public, notary was done, sir. Apostilled document also I'll just show you, sir. how generally a apostille document looks like. So these are done in those countries where Hague Convention is there, sir. Matlab they are the parties of Hague Convention. So you can see this document is apostilled, and you will be seeing he will be issuing one certificate, sir. So they will tell you the country, sir. This document has been signed by the person, signed by this person's name will be there, sir. Acting in the capacity of Secretary of the Commonwealth, bears the seal and stamp of the Secretary of the Commonwealth Pennsylvania. At place also they will mention, sir, etc., sir. So what they are trying to show, sir, कि भाई whoever has signed in front of me, matlab whatever signatures are mentioned, sir, that person has signed in front of me, sir. So this act as a document for witness. Okay, so this is how this apostilled document looks like, sir. So what has to be done now? Notary also has to be done, apostillization also has to be done, sir. Okay, great. So if it was a regular class, we would have discussed 15-20 minutes on this particular topic only. What do you mean by apostillization? What do you mean by notarization? Though exam point of view, they will not come, sir. But can I say, sometimes you have to know what is exactly the meaning of the word apostillization, why it is done, what is the purpose, sir. Anyway, I'm just doing the review of the question paper, so this is more than enough, sir. Now there is an illiterate person, sir, Miss Goma Devi. She is nothing but mother of the subscriber, sir. Now because she is illiterate, she cannot sign. So what has to be done? Thumb impression has to be kept, sir. Now can I say that thumb impression is done, but can I say now we have to write her name and address, we have to write all those things, sir. So for that, another person will come, sir. So this another person, what he will do is, whatever is there in the memorandum, whatever is there in the articles, entire thing ko he will read and entire thing ko he will explain to whom? Goma Devi, sir. After she understands, then she has to put her thumb impression, sir. Then he is going to describe her details. Now how he is going to describe? Can I say she cannot write? No. So can I say now her name will be written, number of shares which she is taking, that also will be written, sir. And then this other person is going to do the authentication. That means he is going to put the signature, sir. Because we want to know this person also, no, who is the person who has explained and who has read in front of that person, sir. So these are the procedures for subscription of a illiterate person, sir. Now there is an LLP. Now can I say LLP is an artificial person? Mohit Electronic Private Limited. Though these people are artificial persons, sir. So as a situation, what will happen? Can I say if LLP has to purchase any shares, subscribe any shares in any company, sir? So can I say LLP has to take this decision? And how LLP is going to take this decision, sir? By passing a resolution of the partners. In this case, that resolution may all the partners have to authorize one particular partner. That partner is going to sign on memorandum and articles on behalf of LLP, sir. Again, the procedure is LLP which is going to subscribe, sir. What they have to do? They have to call for a partners meeting. In that partners meeting, they have to authorize one particular person. Obviously, they have to authorize one partner to sign on the memorandum articles of the company in which they want to subscribe, sir. But obviously consent of all the members is required, sir. Next, Mohit. Again, it is a body corporate, sir. Now because here members will be there, sir, so we don't use the word partners, we'll be using the word board of directors, sir. So again, what will happen? Mohit Electronics Private Limited mein one board meeting will be conducted, sir. In this board meeting, board of directors are going to authorize whom? Either the director of the company or the officer of the company or the employee of the company. What they are authorizing? Ki bhaiya, you go and sign on the memorandum and articles of that company, sir. For example, there is a reason I have downloaded this, sir. So you can see here. Okay, so you can see here, this was one company, sir. In this company, one of the subscriber was company actually. So you can see there is some company, Singapore based company it is, sir. That is a company, sir. Now Singapore based company, what they have done, sir? They have passed one board resolution in their board meeting, sir. In that board meeting, they have authorized this particular person to sign as a subscriber, sir. In other words, he is not subscribing, sir. He is signing on behalf of this Singapore based company, sir. Okay, na? So that is a point, sir. Okay. So with this, we conclude question number 1. So question 1, for the first time, I have seen the past question papers also, sir. So last 7-8 attempts I never found this question being asked in the exam, sir. So this was completely an out of proportionate question it was. Anyway, discussion will always be done, sir, in the class. But the thing is, nobody really expected the question can be on this particular class also, sir. 5 marks the question it was, sir. Okay, great. Next, 1B. So Sangeeta, you are the auditor of the company. You were appointed in the general meeting. Sangeeta met with an accident. Oh, so there is a casual vacancy. 23rd December ko she died, sir. Now, board of directors of ABC Limited. So ABC Limited is not a government company; it is a normal company, sir. Filled up the casual vacancy. Yes, that is allowed as per section 139 subsection 8. Board of directors can fill the casual vacancy and appointed Keshav as the statutory auditor, sir. So we have to understand ki did they do this within 30 days? Answer is died on 23rd December and board of directors has filled. So assuming that they have done in 30 days, sir. The next AGM of the company was scheduled for 28th August 2024. In that AGM, can I say, Mr. Keshav, your tenure will come to an end. Remember, whenever any auditor is appointed in the casual vacancy, for the casual vacancy, sir, he does not have a tenure of 5 years. He does not have a tenure of 5 years. He has a very limited tenure, that is up to the conclusion of next meeting, sir, in which the board of directors recommended for the appointment of Mr. Ashish as a statutory auditor. Very fair enough. But Keshav has objected for the appointment of Ashish and gave representation to the company secretary, mentioning therein that Keshav's appointment was approved by the board of directors after the demise of Sangeeta. Thus, he can continue as a statutory auditor till the conclusion of next 6th GA. No, this is not allowed, sir. And also threatened to report the matter to registrar and NCLT, sir. Can I say, Mr. Keshav, you are a chartered accountant. You should have company law little bit knowledge, sir. And so obviously, all this is completely wrong. So explain the procedure to fill up the casual vacancy of the office of statutory auditor, sir. So can I say 139 subsection 8 is what we are talking about, sir. Let us open casual vacancy, sir. So you can see 139 subsection 8. I am referring the bare act, sir. Any casual vacancy in the office of auditor shall, in case of a company other than, so in other words, not a government company. So our case is, what is a subsection 1 only, sir. Sorry, clause 1 only, sir. So 139 subsection 8 clause 1 has to be filled by board of directors within 30 days. But and he shall hold the office till the conclusion of next annual general meeting. So here you have to observe this particular point also, sir. So this point is talking about tenure. So his tenure is he will continue till the conclusion of next AGM, sir. So Mr. Ashish only, no? Sorry, Mr. Keshav, sorry. So Mr. Keshav, you cannot continue for it. So what is the procedure, sir? Procedure is very simple. ABC Limited is not a government company. So obviously clause 1 will be applicable. Any casual vacancy in the office of auditor shall be filled by the board of directors within 30 days. Such auditor shall hold the office till the conclusion of next AGM, sir. Great. Now, whether the contention raised by Keshav is justified? No, contention raised by Keshav is not justified because he was not appointed in the AGM. He was appointed by the board of directors. And if they are appointed by the board of directors, he has a very limited tenure, sir. So his contention is not justifiable, sir. What shall be your answer if casual vacancy in the office of statutory auditor is caused by resignation of Sangeeta? So can I say resignation ke liye we have this small diagram, sir. So you can see casual vacancy is there. Other than government company, government company. Anyway, we are not talking about government company. Other than government company ke liye, reasons are divided into two parts. If it is for resignation, it is for other than resignation. Till now, we read other than resignation only, sir. Hence, it was to be filled within 30 days by board of directors. But if the casual vacancy arises due to resignation, sir, then ऐसे situation में it has to be filled by board of directors. 30 days का time limit is given. Plus, it also has to be approved by whom, sir? Members. In other words, you can say it has to be ratified by members in the EGM, sir. So, in other words, dual approval is required. Board of directors का approval is also required and members approval is required. Board of directors, you have to fill the vacancy within 30 days. Members, now, from that day, next 30 days, 3 months, you have to call the EGM. In that EGM, members have to give their approval, sir. So there is a procedure, sir. And even this auditor also will not hold the office for a longer period, sir. He has to vacate his office, he has to close his office till the conclusion of that meeting, sir. Till the conclusion of next general meeting, sir. Okay. So I hope this part is clear, sir. Very simple answer, very nice answer, sir. Now let us see 1C. Mr. V is a PIO, person of Indian origin, who has moved to USA, very good, along with his wife in 1998. So obviously he will now become PROY, sir. Has been living until 2024, he was there in US only, sir. Now, he is holding a joint bank account. Achha, 17th November ko his wife died. He returned permanently to India on 24th November, sir. So, 24th November ko he returned to India, sir. Do you think he is a PRI? Answer is yes. If in the previous year he has stayed for more than 182 days, in other words 183 or more, if he has stayed, then he becomes a PRI on 24th November 2024, sir. Okay, anyway, those facts are not given. We will assume that he is now a PRI, sir. He also inherited wife's money after her death. Obviously, the joint bank account में whatever money was there, sir. So he has inherited, sir, which got transferred to his bank account in USA. So still money is lying in USA only, sir. So can I say whatever money was there, it was earned in USA and it is held in US accounts only, sir. After few days of his return to India, he has paid a premium from his bank account in USA of his insurance policy. Acha. And which was taken in USA. So he took life insurance in USA and he is paying the premium also from the money which was earned in USA only, sir. So can I say here government should not have any problem, sir. Referring to the provisions of Foreign Exchange Management Act, examine whether Mr. V is permitted to carry out the above transaction. Answer is allowed. Can I say it is actually a capital account transaction? So today if you see, sir, Mr. V is actually a PRI. I told you, I am assuming that previous year may he stayed in India for 183 days or more, sir. So he is a PRI. Now, can PRI hold, own, transfer the currency, the securities, the immovable property which he has acquired when he was a PROI? Answer is yes. So what we have to observe, sir? Logic is simple. Sir, today he is a PRI, but during this period he was PROI. Now, during this period, sir, whatever foreign currency, foreign, security, immovable property he has acquired, can he continue to hold them in that currency, in that format only? Answer is yes. So, even though he has a PRI today, we are not forcing him to sell the immovable property outside India. He can hold it. He can hold it, he can own it, and if he wants, he can transfer it also, sir. Answer is allowed. Plus, he can also inherit the immovable property from that person who is PROI. Can I say wife was nothing but PROI? From wife only he is inheriting, sir. That is also allowed, sir. So is this allowed? Answer is yes. Can he make the payment? Answer is yes. Remember, LIC payments are nothing but capital account transactions, sir. So hence, that's the reason we are referring to section number 6, sir. Section 6 talks about permissible capital account transactions, sir. Now, let us see 2A. Referring to the provisions of Companies Act 2013, state whether the following amounts received by the company constitutes a deposit or not, sir. Now, can I say deposit ke liye we have section 2 clause 31, sir. Now, if you read this definition, sir, you will find any receipt by the company is a deposit, sir. Now, for that we gave some exceptions, sir. So rule 2, sub rule 1, clause C, and this is the rule number which I tell students you have to pakka remember, and you have to just mug this up. So rule 2 1C, rule 2 sub rule 1 clause C. So rule 2 sub rule 1 clause C, this is the rule which will tell you list of those items which are not a deposit, sir. Now tell me, whatever money company receives is actually a deposit if you read 2 clause 31. But in that receipt, if that amount falls within the list of items given in 2.1c, then it is not a deposit, sir. So now we have to find out whether it is deposit or not, sir. Now can I say, if you don't see 2.1c, all 3 items are a deposit, sir. So now we have to check whether 1, 2, 3 comes within the categories of list of items defined in 2.1c, rule 2, sub rule 1, clause C. IQ Books Limited received share application money of 50 crores from investors. Great. on 8th December 2024. As the issue was undersubscribed, the company refunded the amount to investors on 20th February 2025, sir. Now, can I say what is the rule talking about, sir? Whenever company is issuing any shares, sir, so they have to do the allotment within 60 days. And if they are not able to do the allotment within 60 days, sir, they have to refund the money in next 15 days. And if they are not doing this from 76th day, it will be treated as deposit, sir. Now, can I say here company could not do the allotment, sir. So issue was undersubscribed, they could not do the allotment, sir. And now they are doing refund, sir. So now what we have to check is within 75 days of the acceptance, are they refunding it, sir? So can I say mathematical calculation you have to do, sir. Now, when they have received, sir, 8th December 2024. So yeah, amount received is on 8th December. 60 days from the date of receipt will be 6th February 2025. 15 days from 6th February will be 21 to 2025, sir. But can I say company has refunded one day before only, which is 20th February 2025, sir. Hence, it is not a deposit, sir. Clear? Now, obviously, exam you have to not write this much only. These are only numbers I have put, sir. You have to write the provision also, sir. Okay, company, if they receive the money as a share application money, they have to allot the shares within 60 days, and if they are not doing allotment, sir, they have to refund it within next 15 days, and if they don't refund within 15 days from 76th day, it will be treated as a deposit, sir. And you have to write that and then show this calculation, sir. Okay, so first amount is not a deposit, sir. Great. Second point, sir. Suraj, Raj and Tejas are the promoters of the Precious Jewelers Limited, sir. They borrowed a sum of rupees 200 crores from the ABC for its working capital purpose. So they are doing some borrowings. Remember, any borrowings from the bank is not a deposit. 2(1)(c) may this items comes. The bank has imposed a stipulation that the promoter should contribute. Acha, company is taking money from promoters. Is this a deposit? Answer is yes. But if company is taking loan from promoters because bank has put a stipulation, then it is not a deposit, sir. This is clearly mentioned, sir. Okay. So bank has imposed a stipulation is nothing but a condition, sir. In other words, bank is saying, okay, we will give you loan, but promoters, you also has to give some loan, sir. So here the point was 200 crores may 20% who also has to bring, sir. These three promoters have to bring, sir. Now, can I say internal proportion could be 10 crores, 15 crores and 15 crores. Now the question is this 10, 15, 15, that is nothing but kitna 30, 40 crores a deposit? Answer is no. Remember, loan from the bank is not a deposit. Loan from promoters is generally a deposit, sir. But if this loan promoter has given because bank has put a condition, then it is not a deposit, sir. Provided the tenure of the loan of the promoter should not be more than the tenure of the bank. In other words, if bank has given loan for 5 years, promoters ka tenure should also be for 5 years. It should not be more than 5 years, sir. And that is the logic, sir. You can see here. This is also given in Rule 2, Sub Rule 1, Clause C. Any amount brought in by the promoters of the company by way of unsecured loan, very, very important, sir, in pursuance of a stipulation of a lending financial institution or a bank is not a deposit. Hence, in this case also, because of the stipulation they brought, it is not a deposit, sir. Third point, sir. Now, actually, third question was little tricky, sir. I am hoping, sir, at least 100 students may, sir, 90 students might have definitely committed mistakes in this particular question, sir. Let's see whether you did or not. Pretty Cosmetic Limited issued, okay, they issued NCDs, non-convertible debentures, sir, and they are listed on recognized stock exchange, adhering to SEBI rules also. The company created a charge on its assets in favor of the debenture holder, sir. Now, question is this a deposit, sir? Now, remember, now very beautifully ICA has played this time, sir. Sir, if you are having NCDs, non-convertible debentures, listed on stock exchange, then they should be secured or unsecured? Unsecured. But here, in this case, company has created a charge. Hence, it will become a secured deposit, sir. Hence, and this is treated as deposit, sir. So, in this case, it will be treated as deposit, sir. I hope this point is clear, sir. Or what I will do is, I'll just show you the point, sir, here. And remember that non-convertible unit. Meetings. So let us see debentures point, sir. So this was very, very beautiful question. This was asked, sir. So just now, if you can see, okay, no, providing services of immobile long-term projects, performance contracts, supply of goods, amount received from, yeah. Just now, if you can see, sir, amount received from promoters. So promoter giving loan to the company, such loan is not a deposit. But what is the condition? Such loan should be unsecured. Such loan is brought by under the stipulation. Exemption will be given only till the loan of the financial institution is repaid and not thereafter, sir. So right now, that is not the part we are discussing about debentures. Debentures. Yeah. So you can see any person, if he is giving a money, any person, if he is giving money to the company and company is issuing a bonds or debentures, that money is not a deposit. But first, that debenture should be non-convertible. In our case also, it is non-convertible. The debenture should be, in our case, charge was created, but here it should be unsecured. And third, listed. There also it is listed. So what we have observed, question may condition 1 and condition 3 is satisfied. Condition 2 is not satisfied, sir. Hence, it is a deposit, sir. You know, or in this category, it did not fall, sir. One more point is also there, sir. So if at all company is raising money by issuing secured debentures, then also it is not a deposit, sir. Then for that, another conditions are there, sir. So any person is nothing but debenture holder. They are giving money to the company by company is issuing bonds or debentures. Such receipt of money is not a deposit. But what is the condition, sir? That should be secured. Yes, that is also secured, sir. But their facts were not given, sir. Here security should be given by first charge, sir. So there those points were not written, sir. Second, sir, on which assets that security has to be done, sir? Those assets which are referred in schedule 3. In other words, intangible assets should not be there. Even this point is also not written in the question, sir. And it should be fully secured. Fully secured means amount raised by issuing bonds or debentures should be less than or equivalent to market value of the assets charged, that is assessed by the registered valuer, sir. So all these three conditions, if they are fulfilled, sir, then whatever money, whatever loan which company is accepting by issuing secured or to say deposits will not be treated as a deposit, sir. But in this case, all these three conditions ka inference is not given, sir. So hence that's the reason I will say this amount is a deposit, sir. Okay, great. Next point, sir. 2B. Spark Services Limited has issued a prospectus. The prospectus mentioned Mr. T is one of the director of the company. He is a social worker. The prospectus also mentioned certain percentages of funds will be utilized for community service. Very good. Mr. C is really impressed by these statements and subscribed to the shares of the company. He was allotted 1000 shares. Acha. So 1000 shares he got, sir. He subsequently sold 250 shares to Mr. D on 16th December 2024. So prospectus was issued on 18th June. Later on, 16th December 2024, he came to know who is he, sir? Here, Mr. C came to know that Mr. T was not the director of the company. Acha, prospectus mate was written that he is a director, but actually he is not a director. And prospectus mate was written such percentage we will be giving to community service, but company never had intention of doing community service. So obviously this prospectus is a misleading prospectus. And if at all it is a misleading prospectus, sir, so obviously civil liabilities and criminal liabilities will involve, sir. Mr. C and Mr. D wants to rescind the contract, sir. Referring to the provisions of company, examine whether Mr. C and D can rescind the contract, sir. So can I say here, as such, if you try to see the Companies Act, may nowhere such words will be written whether rescind, what to say, cancelling is allowed or not allowed, sir. Here, little bit of common sense we have to apply. Can I say Contract Act we have studied? I'm talking about in foundation, sir. Contract Act may, whenever consent of the person is obtained by doing fraud or misrepresentation, whenever the consent of the person is obtained by doing fraud or misrepresentation, the contract is voidable at the option of aggrieved party. Now here D will not come. Reason, prospectus was issued and who subscribed at that time? Mr. C only has subscribed. So in other words, So fraud or misrepresentation, company did fraud or misrepresentation with Mr. C, है ना? So here let us try to analyze between company and Mr. C, sir. So yes, there is a fraud, there is a misrepresentation, sir, and based on that only consent was obtained, sir. ऐसे situation में can I say contract will be voidable at the option of Mr. C? Now when I say voidable, that means what, sir? He can cancel the contract plus ask for damages. When I say cancel, that is nothing but rescind, sir, है ना? So this type of answer is given in section number 35. But if you see 35, direct words are not given, rescind, cancel, etc., sir. So there you will be only finding what, sir? Aggrieved party can claim compensation, that is nothing but damages, sir. Can I say when they are claiming damages, in other words, they are cancelling the contract, sir. है ना? Now, एक बार what we will do is just refer section number 35, sir. 34 talks about criminal liability, 35 talks about civil liability, sir. So this question is not talking about criminal liability, it's talking about only civil liability, sir. Okay, so let us see 35, where a person has a subscribed. Answer is yes. In this case, Mr. C has a subscribed, sir. So okay, or it is, let us see from Bail Act only, sir. It will give you more better opinion, sir. Where a person has a subscribed for the securities of the company, acting on any statement included or inclusion or omission of any matter in the prospectus which is misleading. Yes, can I say omission was there, sir? So wrong statements were written, sir, and has sustained any loss as a consequences thereof, the company and every other person. So can I say these people have to pay compensation, sir? In other words, you can say you can rescind the contract, because I told you if you cancel, then only you are claiming the damages, sir. And can rescind the contract to every person who has sustained the loss. Okay, great. So now can Mr. C and D rescind the contract, sir? So can I say C can rescind the contract to the extent of 750? Reason is 250 has already sold to Mr. D, sir. But can Mr. D rescind the contract? Answer is no. Reason is, can I say misleading prospectus was issued. Mr. D, you never subscribed the shares by seeing the prospectus. So obviously company never did any fraud, any misrepresentation on you. It's simple hai. Spark Limited, company has done fraud or misrepresentation to whom? Mr. C, because company issued prospectus, Mr. C believed that prospectus to be true, and then he has incurred the loss. But can I say D never took the shares taking prospectus as a base, sir. He has taken the shares from the secondary market, sir. Hence, Mr. D, you cannot rescind the contract, sir. So that is the logic, sir. So Mr. C, you can rescind the contract. Mr. D, you cannot rescind the contract, sir. So similar facts were given in Mr. Peak versus Gurney. Now this is a very popular case law. In our book also this was mentioned. If you all, you can see in our material, sir. Multiple times this question was asked. Peak versus Gurney, Peak versus Gurney, Peak versus Gurney. So, and in class when I was discussing, I told you this is a very, very important question, sir. Okay, let's see 2C. So there is Purva building, some PBL company is there. It is having 2 subsidiaries. Purva is CFO of that particular company, sir. Ashish and Mrinal were the CFOs of ACL and SBL, resigned from their respective companies. Acha. So in this subsidiary company, Mr. Ashish, Mr. Mrinal were CFOs. They resigned from that company, sir. And now Purva was offered to take charge of the office of CFO in ACL and SBL, which she has accepted. Whether Purva can be designated as CFO simultaneously in 2 subsidiaries besides being CFO of PBL. In other words, having so holding company is PBL, sir. PBL mein already Purva is a CFO. Can she also become CFO? Can she also accept CFO position in ACL and SBL? That is nothing but subsidiary companies. Examine the matter with reference to the provision containing Companies Act as well as okay. Now here it is a very, very typical question, sir. Good thing is this question is as it is brought from the textbook back, sir. So if at all you see I say a study material, sir. So that's the reason faculties keep on shouting. Not only me, every faculty, sir. Bhaiya, textbook ka end mein whatever questions are there, you please look after them, sir. So General Clauses Act ka end में if you see textbook back questions में third question is there. This question is similar to that particular point, sir. Okay. Now here, whether this is allowed or not, why this question has come, sir? Sir, Companies Act में if you see section 203 subsection 3, उसमें it is written, if a person is a KMP in one company, he can be taking the KMP position in another company provided that another company is a subsidiary company. So there the word used is another company should be a subsidiary company. Company, singular was there, plural was not there, sir. So now tell me, sir, can I say in our case, Mr. Purva, you are holding a KMP position. Now KMP is defined in section 2 clause 51, sir. So there you will be finding CFO, MD, WTD manager, CEO, CFO and CS and person who is designated as KMP and such other person as may be prescribed. So these are the 8 people who are defined in section 2 clause 51 as KMPs. In that CFO is there, sir. So now I will not tell as CFO, I will be just using the word KMP, sir. So if you are a person, you are a KMP in one particular company, can you become KMP in another company? Answer is yes, provided that another company is a subsidiary company. That means only one, singular is written. But can I say in this case, there are 2 subsidiary companies, sir. So question ye hai, can he accept in both the companies? That is the question, sir. So can I say what you have to observe now, is this permissible or not permissible? Now for that, General Clauses Act also you have to refer, Companies Act also you have to refer. Companies Act में तो clearly it is mentioned 203 subsection 3 में clearly it is mentioned if you are a KMP in one company you can become KMP in another company provided that company is a subsidiary company, sir. Now section 13 is there in General Clauses Act which talks about gender and number. Now number में you will be finding unless the context otherwise require, whichever section में, whichever law में singular word is used, you can also include plural. So even though the word used is subsidiary company, you can read this as a subsidiary companies, and then this appointment is allowed, sir. So Apurva, thus the whole time key managerial person may hold office in more than one subsidiary company as per the present law, nothing but Companies Act, sir. Okay, so that was General Clauses Act, 4 marks, very beautiful question, sir. Now thing is, writing this section 203 subsection 3, I don't think it will be very easy for the students unless they have gone through the textbook back questions or the faculty have discussed this provision in the class. Otherwise, it will become very difficult to remember 203 subsection 3, sir, because they don't know what is the, they are asking you to refer Companies Act, but can I say which is section 203? It is not part of our syllabus and it is very difficult for a student to remember that also, sir. Plus, it is very difficult to know कि General Clauses Act में where they are referring to, singular, plural, and that idea also you will get only if you have knowing section 203 subsection 3, sir. Sir, because it is there in the textbook back, so I will not say it is out of syllabus, sir. It was there in our book, and as a student, we are supposed to read the study material, sir. Now, this is a straightforward question, sir. Comment on the following. Disclosures requires to be made on the face of the prospectus. Can I say 26 subsection 6 says what, sir? Whenever you are issuing any prospectus, in fact 26 talks about contents of prospectus. Whenever you are issuing a prospectus, sir, on the face of the prospectus, you have to write that this copy of prospectus was filed with the ROC, sir. You also have to specify documents which are required to be attached. These things has to be written on the face of the prospectus, sir. Very good, sir. Now conditions with regard to expert statements. So if at all company is making any declaration and the declaration where they are mentioning the name, this type of points were given by any expert, sir, you can include those experts ka statement in the prospectus provided. What are the conditions, sir? It is given in subsection 5. Sir, that expert should not be that person who is connected with the company, meaning he should not be interested in the formation, promotion or management of the company, either presently or in the past, sir. Plus, that expert should have given written consent. Written consent for what? His statement can be included in the prospectus. Like that, he has to give one written consent. Plus, that written consent should not be withdrawn when the company is delivering the prospectus with the registrar, sir. Plus, on the prospectus face page it is mentioned these 2 points are satisfied. So that also has to be written, sir. If all these conditions are fulfilled, then you can include that expert ka statement in the prospectus, sir. And last point is what, sir? Date of publication of prospectus. Subsection 3 में if you see explanation is given, 26 subsection 3 में एक explanation is given sir. Whatever, now every prospectus has to be dated and signed. Whatever date you mention, the date indicated in the prospectus will deem to be the date of publication sir. So that is there sir. So what is the significance of this? Obviously you have to refer your main class sir. Now let us see 3B sir. Vittal Pharmacy Limited is engaged in manufacturing of medicine to cure skin diseases. Okay, it has one unit in Germany, sir. It has few patents in Germany and raised funds by creating a charge on the stock in Germany and patent rights. Great. So they are having one division in Germany. Germany में some assets are there. On that assets only they have raised loans and created a charge. So company has registered the charge on the stock but did not register the charge on the patent rights. ये तो गलत है. The company received a notice from the ROC for not filing the particulars of charge created by company on the property or asset situated outside India. The company wants to defend the notice of the ground that it shall not be the duty of the company to register the particulars of the charge created on the patents obtained outside India, and also they are intangible in nature. Referring to the provisions are going to examine the validity of company's claims. So if at all you see, there is a concept of registration of charge. Registration of charge के लिए total we will be reading section number 77. 77 subsection 1, if at all you open sir, you will be finding beautiful lines. So whether property situated in India or property situated outside India, whether it is a movable property or immovable property sir, whether it is a tangible property or intangible property sir, company you have to register the charge. 77 subsection 1, you can see duty of every company creating a charge in India, outside India. Property can be tangible or intangible. Now what you have to do, you have to register the particulars of the charge. Obviously form number is CHG1 because debentures are not involved here. So, and within how many days it has to do that sir? 30 days. Obviously relaxation is also there, but here that is not the question. So what is the question sir? Whether whatever is the contention of the company, is it valid? Answer is not valid sir. So company, what you have to do, you have to register this charge. Even though it is a patent, even though it is outside India, still you have to register it, because on intangible assets also situated outside India also charge has to be registered sir. Okay na? If it is created, you have to register. That's it sir. Okay, or 3B में ही one internal choice question was given sir, which was, what do you mean by floating charge and when you will convert, when it will be converted into fixed charge? Now remember, conversion of floating charge into fixed charge is called as crystallization of floating charge. Now what do you mean by floating charge? Whenever a charge is created and company which is borrowing does not have right to deal on in that assets, that type of a charge is called as floating charge. So what is a floating charge sir? A charge in which without the consent of the charge holder, company cannot deal. So a charge in which without obtaining the consent of the charge holder, company can deal in such asset. Company can nahi hai, company cannot, small mistake sir, deal in such assets in the ordinary course of business is a floating charge. In other words, without taking the permission from whom? From the charge holder. If you cannot deal in that asset, then that type of a charge is called as floating charge. Generally, they are created on class of assets, sir. And generally, they are created on class of assets, sir. So these class of assets will be circulating, fluctuating, or changing their nature, sir. Now, what do you mean by crystallization? Crystallization is nothing but floating charge holder. Floating charge will come to an end. That is nothing but floating charge will convert into fixed charge. This process is called as crystallization. Under which situation this will happen? Can I say I took one example of a bank and a banker is sitting on the first floor, like that example I have taken sir. Anyway, when this charge will come to an end, when the crystallization will occur sir, when company goes for winding up, company cease to carry on the business, or receiver is appointed, 84 if you can refer sir, company makes any default sir, and in payment of interest or repayment sir, in all these cases, and floating charge holder will crystallize it sir, and then becomes fixed charge sir. So this was also a very straightforward question sir. In fact, for this particular section, no section numbers are involved sir. Floating charge के लिए no section numbers you will write sir. In fact, nowhere in the Companies Act they have defined what is a floating charge. Though rules may one place may floating charge word is used, but nowhere in Companies Act it is defined. So this is a general meaning, sir. It is not as per any section of Companies Act, sir. Next, 3C, nocitur associ, sir. Now what do you mean by nocitur associ? Construction of associated words, or and a word is known by the company it keeps, sir. So एक example also I have taken, sir. Now if a law says no vehicles such as car, trucks, motorcycles are allowed in the park. Now can I say car, truck, motorcycle? They are specific words. No vehicle is a general word. Now question is, this general word ko should I give a very wider meaning? Answer is no, because if I give vehicle ko very wider meaning, sir, aeroplane will also come, helicopter will also come, Rafale will also come, sir, है ना, all those missiles will also come, sir. So can you allow them in the park, sir? Answer is no. Hence this vehicle word has to take its meaning from these specific words. Can I say car, trucks, motorcycles? They are all nothing but what, sir? Two wheelers. Sorry, they are all automobiles. Hence in vehicles what will only come? Automobile will only come, sir. So do you think bicycle will come now? No. Aeroplane will come now? No. Helicopter will come now? No. So all those automobiles will only come within the definition of this vehicle. That is what it is given in this particular thing. In class 4-5 examples I have taken, sir. Anyway, now 4A. Now this was very important answer. When we were discussing in the class itself, I told you in the accounts of company, sir, provisions relating to audit trail, etc. sir. Very important it was. XYZ uses an accounting software for recording its financial transaction. So can I say accounting software? So all audit trail concept will come only if you are maintaining your books of accounts in e-form, sir. Is company allowed to maintain their books of accounts in e-form? Answer is yes. Second proviso to section 128 subsection 1 allows company to maintain their books of accounts in e-form. Now uska procedure manner is given in rule number 3, sir. Okay, now the statutory auditor of the company while auditing finds the following issues. Some general entries were altered. Now alteration is allowed, but when you do the alteration, uska log has to be created. Log is nothing but what, sir? We have to record what was the journal entry before and what was the journal entry afterwards, sir. Without creating an edit log. That means what, sir? What is not created? Logs are not created, sir. So do you think this is right? Answer is no. As per rule 3, this is not allowed. Sir, whenever you are doing any alteration, sir, now that edit log has to be created, sir. In other words, what was the journal entry before, what is the journal entry afterwards? That log, that register has to be created, sir. So is this allowed? Answer is no. So keeping in view the above issue, advise the company on the following: audit trail and edit log requirements. So audit trail feature has to be enabled plus edit log and requirements has to be made, sir. The audit trail feature was disabled. Can I say this is also not allowed, sir? So you can see here, every company which uses accounting software for maintaining the books of accounts shall use only accounting software which has a feature of recording the audit trail, sir. What do you mean by recording the audit trail? Step by step, what happened earlier, what happened later, sir. And for each and every of the transaction, for every transaction, audit trail has to be recorded. And edit log also has to be created. And audit trail should not be disabled. It's a simple bhasha, Raja. So imagine a scenario, internet, Chrome में you are visiting some websites, sir. So can I say whatever websites you are visiting, sir, uska history has to be created. That is what I mean by audit trail. But can I say you are very clever, sir? You are having the option of deleting the history. Here that option should not be there, sir. So audit trail cannot be disabled and deletion should not be allowed, sir. That is what they are trying to say, sir. Next, second point is backup of books of accounts. Because you are maintaining the books of accounts in electronic form, there is a high probability you may lose the data, sir. So hence provisions for backup is also there, sir. So whatever books you are maintaining in electronic form, sir, uska backup has to be kept in the servers physically located in India on a daily basis. Earlier daily basis word was not there. This was inserted via amendment, sir. So hence on daily basis you have to take the backup, sir. So this is rule number 3 read with second proviso to section 128 subsection 1. Very important answer. I told you this. Now 4B. This is a question relating to LLP, sir. Sunroofing's LLP has 6 partners. Mr. K is a partner in charge for marketing division. He is actually the face of the company, sir. LLP, sir. Mr. W is senior partner, is also an investor. Now Mr. K, who is the face of the firm, he is dead now. He died, sir. The LLP is now continuing its operation without dissolving the LLP, sir. Great. The firm incurred a huge loss after his death. His matlab K ka death, sir. And K's share in the firm was also utilized to repay the debt, sir. Is this allowed? Let us see. Mr. W, can I say this person who is the major investor, sir, transferred his shares to his son M, who has the previous experience in the marketing. Achha. Now remember, we have only done the transfer of his shares. We did not make him the partner, sir. We did not make him the partner, sir. Remember, is this allowed? Yes, assignment of rights are always allowed. As per LLP Act also it is allowed. As per Contract Act also it is allowed. Always remember, rights can be assigned. Duties or liabilities cannot be assigned, sir. So can I say partnership share for Mr. W is a right. Now he wants to assign his partnership share to his son. That can be always done, sir. Not allowed problem. But remember, just because W has assigned his rights to Mr. M, that doesn't mean M becomes a partner. That doesn't mean W will cease to be the partner. W is still the partner. M is not at all a partner. In other words, he has no say in the LLP, sir. M wanted to take active part in the business. That only I was telling. You cannot take any active participation because you are not the partner. But the remaining partners did not allow him. Obviously, they are having this right, sir. Referring to the provisions of LLP Act, state whether K's share can be used to repay the firm's debt after his death, sir. Now, here you have to understand one point, sir. Can I say Anna died on this particular death, sir? Now, can I say during this period, he may be having some share. So, capital contribution, profit contribution, he will be having whatever money is there, it is there, sir. Can I say during this period only, if at all LLP has done some business and LLP has incurred some loss, so can I say he died on this period? During this period, so he was the partner, no bhai. So can I say whatever loss which is contributed to that particular business which was done before his death, can I say that loss can we adjust against the share? Answer is yes, sir. And so that is what I have written. As per section 24 of the LLP Act, upon the death of a partner, LLP is not dissolved. The LLP agreement typically governs what happening to the deceased partner shares. Now remember, exact language of 24 I have not written, sir. Little bit of twisting I have done, sir, for convenience. Exact language ke liye you have to refer your textbook, sir. The legal representatives of deceased partner may either become the partner. Now remember, you can become a partner only upon the approval from existing partners, or receive the capital contribution and share in the accumulated profits. That is allowed. But can I say when? After settling the firm's liability, sir. Now can I say if firm has incurred any losses, so that is also a liability, sir. And the share of the deceased partner is subject to the liabilities of the LLP, meaning creditors of the LLP will have first claim and only the residuary balance part will go to the deceased legal heirs or estate. Therefore, using Mr. K's share to repay the LLP debts is valid and it is in accordance with the law, sir. Second question, the remaining share of Sun Roofings the remaining partners of Sun Roofing can forbid M to take active participation in the business. Yes, this is allowed as per section 42. Now here what you have to remember, sir, Mr. W, you can transfer, you can assign, transfer word I should not use, sir, you can assign your partnership interest to your son, allowed. But that doesn't mean M will become a partner. He will have no say in the LLP because you continue the partner, you continue to be the partner, not your son. So can remaining partners stop him? Answer is yes. You can read this answer, pause the video, you can read this answer. Conclusion I am writing, sir. Thus the existing partners can prevent M from participating in the business, sir. So this was section number 42, sir. Earlier was 26, sir. 24 and this was 42, sir. Okay, great. 4C, sir. Whether illustration will have the effect of modifying the language of the section in connection? Answer is no. Can I say in any act, why illustrations are given? Sometimes when you read the provision, there could be some ambiguity, sir. So to give clarification, to give properly explain that provision, lawmakers introduce something called illustration, sir. Again, in any law, whenever you're reading any provision, sir, sometimes there could be some ambiguity, sir. You may think in some other manner. So to provide better clarity, lawmakers introduce something called what, sir? Explanation. So explanations are always clarifactory in nature, sir. Explanations are always clarifactory in nature, sir. They are not defining or not describing a new law. Whatever is already written, that only we are explaining, sir. So can illustration have the effect of modifying the language? Answer is no. What do you mean by modifying the language? Whatever provision is written, can illustration define in such a manner which is going beyond what is written in the provision? No. So can I say that is not allowed, sir? So no. Illustrations are not any law. They are not substantive law. They are not passed in parliament as such. They cannot restrict, modify, extend the language of the statutes. If a illustration is doing like this, at any point of time, there is a clash between the illustration and the provision, then what will always prevail? Provision will always prevail. Section will always prevail. Always remember, because of dash, dash came. Because of section, because of provision, illustration came, sir. So can I say, when because of section provision came, because of section illustration came, so section should prevail over the illustration. So that is a logic, sir. And example they asked, so this was the example quoted in the textbook. As it is, I have copied, sir. Now what are the functions and duties of NAFRA? Can I say, you can refer 132, easily you can get it, sir. Now find out the differences between any five differences between LLP and LLC, sir. Can I say, this is that type of a question which in dreams also, and I did not expect ICI to give, sir. Itna lollipop question they gave, sir. In other words, they are just asking you, write the difference between LLP and a company, sir. LLC is nothing but limited liability company, sir. What are the differences? Can I say many differences? You can say, sir, there those people are called partners, here they are called members. Sir, their concept of designated partners is also there, partners is also there, sir. Here members and directors are there, sir. Can I say there regulating act is LLP act, here it is companies act, sir. Can I say name may, you will be writing LLP there, here you will be writing private limited or limited there, sir. There is a concept of listing also which is not there in the case of LLP, sir. And a number of members or partners, you can write LLP may minimum partners required are 2, maximum could be infinite, sir. Can I say here private company, public company may members ka criteria will different, sir. So like this you can easily write, sir. Very, very easy question this was, sir. 5C. Dream Builders Limited was engaged in the activity of building and selling budget-friendly apartments. It recently started a new project at Noida. Pending approvals, the builders started the construction work. Wow. Approval is not yet received. They started doing the construction also. On verification of the documents, the Corporation of Noida refused to sanction. Sanction is nothing but approve the permission, and the assistant commissioner Mr. S issued a demolition order, because without permission only they started doing the construction. No, now they are not giving the approval, sanction is not given, hence we have issued the order of demolition, sir. Who has done that, sir? Assistant commissioner, sir. Great. The builders filed an appeal at the court and stayed the demolition. Stayed matlab kya, sir? Stopped. Stay order, you know, injunction order, sir. After 6 months of the court trials, the verdicts was announced in favor of Corporation of Noida. In other words, whatever assistant commissioner said, that is now allowed, sir. But at that time, Mr. S was the assistant commissioner. In this 6 months, Mr. G became the assistant commissioner, sir. Now, because of that, Mr. G started doing the demolition, sir. अब देखो builders का कितना दिमाग लगा है, sir. What brains they are applying, sir. Now, builders are arguing that कि demolition order was issued by Mr. S. Hence, Mr. S is not there, since he is no longer in the authority. Whatever order they have given will stand cancelled. Mr. G cannot demolish the construction, sir. Referring to the provisions of General Clauses Act, determine the validity, sir. Now here you have to understand one point, sir. Whenever any orders are passed, do you think whenever a person is passing the order, sir, do you think individual powers are given? That office is having that power. Now remember, assistant commissioner is one office. That office may, who was there? Mr. S was there. Persons may keep on changing. Persons may keep on changing, but office will remain constant. So today this office is represented by Mr. S. Tomorrow it will be represented by Mr. G. Can I say this is the concept of successors? So if one person has passed that order, sir, that will continue moving forward also, even if that person is not there, sir. That was the concept which was brought in General Clauses Act section number 18, sir. So you can just see this thing, sir. Now this is one line which I added for better understanding. Administrative powers and functions are attached to the office and not to the individual. So an order passed by a competent officer in their official capacity continues to have legal effect even if the officer is replaced or officer is transferred. Hence, whatever is the contention of whom, sir? Company, that is, sorry, builders, is it valid? No, it is not valid, sir. Section number 18. Remember, here section 18 I did not quote, sir. Just a proper reasoning I have given. 18 you have to write, sir. Okay, now section 18 ka content you have to write, sir. Chaliye, sir. More 3 questions. 6A. So there is one company, they have obtained a loan 300 crores from SPM Bank, sir. So for that loan, they have given some asset as a security. Very great, sir. Charge was also created, CHG1. September 2024 May, they fully repaid the loan, sir. And bank also has issued no due certificate, sir. Great. Then later on, this company, DNC Hydroelectric, sir, failed to file CHG4. Now, what is CHG4? As per section 82, within 30 days, you have to file form of satisfaction of charge. And 30 days, it was not filed, sir. In January 20, now remember, when this satisfaction occurred, sir, September 2024 May, satisfaction is over. So, 30 days, they were supposed to do the filing. In January 2025, RTS Bank approved a loan of 1000 crores to DNC for acquiring new plant and machinery. During the due diligence, RTS Bank discovered that the old charge was still active in ROC's record. In other words, obviously it will be active only. ROC is not a god, no? So if at all satisfaction is over, company, it is your duty, go and intimate to whom? ROC. You did not do intimation under section 82, sir. And thereby it is creating a problem for disbursement of new loans. As a financial advisor of the company, advise the legal and procedural steps which DNC Hydro company has to follow to remove the old charge. Now what you have to do? Simple logic here. Can I say charge is satisfied on which day? Day is not given, September 2024. 30 days may you are supposed to do the filing of CHG4 as per section 82. You did not do. No problem, sir. Sir, you can do still in 300 days. 300 days from satisfaction of charge. In other words, you are getting extension of 270 days, sir. Now, can I say January 2025 may they are taking a new loan, sir? So, obviously, yeah, within the time limit only, sir. So, hence 300 days are not over. So, can company still make an application? Answer is yes. CHG4 they have to file, sir. But in this case, they have to pay normal fee, additional fee. They have to pay additional fee, sir. That is the procedure, sir. So where the charge is paid or satisfied in full, intimation has to be given within 30 days, CHG4. Registrar may, on an application by the company or the chargeholder, allow such intimation to be done within a period of 300 days. Now remember, 300 days from 300 days of payment or satisfaction. So it is not extra 300 days, it is 270 days extra we are getting, sir. So 30 days from the date of satisfaction, sir. And here also 300 days of the date of satisfaction, sir. That is the point, sir. So DNC Hydroelectric should file the form by paying the additional fee. Which form they have to file, sir? CHG4, sir. So what is the procedure they have to follow? They have to follow CHG4, and that form, if it is digitally signed with the banker also, sir, then there will be no problem. Immediately ROC is going to record the satisfaction in their records, sir. 6B. ABC Inc. is a company based in USA, developed security software and sells in Indian clients. Very good. So you are having a place of business in India. In that place, you are also doing some business activity and you are a company incorporated outside India. Very good. You are a foreign company as per section 2 clause 42. Sir. ABC Inc. has entered into a service agreement with PQR Private Limited, a company incorporated in India. PQR Private Limited provides support to Indian customers for the software installation and after sales service. PQR Limited also holds 50% shares of ABC Inc. Wow, wow, wow. So can I say you are a foreign company? In that foreign company, who is holding shares, sir? An Indian company is holding the shares, sir. Explain whether ABC Inc., that is foreign company, is required to comply with the provisions of Chapter 2. Chapter 22 is nothing but company incorporated outside India provisions. Now remember, sir, you are a foreign company, a special foreign company. Now, when you will be a foreign company, when you are a company incorporated outside India, having place of business in India, doing business in India, you are a foreign company. But in that entity, if Indian company is also having 50% or more of the capital, sir. Now, how they can have, sir? Either Indian citizens may have, or Indian company, one or more body corporates incorporated in India, or Indian citizen and one or more body corporates. Any permutation combination, if 50% or more of the paid up share capital of the foreign company is there with Indians, then as a situation may, I used to give a special name, which is, it is a special foreign company. It is a special exam. I told you don't write this. It's a special type of foreign company. And jaise you become a special type of foreign company, you have to follow chapter number 22. You have to follow chapter number 22. Plus, you also have to follow such other provisions as may be prescribed by central government. In other words, normal compliance, extra compliance is there, sir. So that is what it is, sir. So whether ABC required to comply with provisions of chapter 22? Yes, not only 22 plus other provisions as may be prescribed by central government, sir. As if means deeming, sir, it is a company incorporated in India, sir. And what is a foreign exchange? What is a foreign security? Can I say direct questions were given? Section 2 clause N defines foreign exchange. Section 2 clause O defines what is foreign security, sir. Okay, so this was your question, sir, and this is how the trend this time was. Can I say most important chapter, which is nothing but what, sir? Share capital. Lengthiest chapter, sir. In that no theoretical question was asked. Wow, this was a big surprise, sir. Most of the students who would have given enough time in reading share capital chapter, even one theoretical question did not come, sir. Yes, 2 MCQs came, sir. Then another chapter, which is meetings. Can I say this is also one of the lengthiest chapters, sir. Second lengthiest chapter, sir. From here also they did not ask any theoretical question. Yes, 3 MCQs were tested, sir. And mostly, sir, rarely we expected prospectus chapters may say, 2 5-mark questions came, sir. It came, and that too one was the direct question, sir. Similarly, charges chapter se bhi 2 questions came, sir, and also from accounts of companies also 2 questions came, sir. Whereas dividend chapter was completely ignored. Preliminary chapter, one question was asked in the form of MCQ, that securities definition, if you can recall, sir. LLP Act say 10 plus 4, 10 marks for theory, 4 marks, 2 MCQs were asked, sir. And can I say other laws is always the savior, sir. You can see here theoretical marks, theoretical papers are also coming, sir, and MCQ part is also coming, sir. So can I say if at all somebody really focus more on other laws, easily you can score your 30 marks there itself, sir. And remaining though is just a formality which you have to complete toward examination, sir. So what is my observation, sir? Paper was really lengthy, sir. I do agree. Can I say reading these many questions will at least take 20 to 25 minutes, sir, including MCQ I'm talking about. So that means as an average student, sir, 30 minutes you will be spending on reading and understanding the topics. Remaining 2.5 hours may you have to attempt. So paper was lengthy. In fact, I will not say it is a paper, sir. It is a question book which was given by ICAI, sir. Time management will be obviously difficult, sir. Sir, paper was very, very easy, sir. So I don't find any tricky questions, no calculations, and no, generally in law paper, I do ask students to carry calculator, sir. In this case, there is no calculations involved, sir. So obviously most of the questions are direct, no calculations are involved. Important chapters like share capital, important chapters like management, no theoretical questions asked, completely they were ignored, sir. And can I say MCQ to ekdam rappa, you can easily complete them, sir. Very, very simple MCQs they were, sir. So that was the analysis of your CA Inter May 25 corporate and other law papers, sir. So I hope you like this analysis, and if you are watching the video by this time, obviously I am hoping that you continued till this time also, sir. So please do consider subscribing to our channel and liking to this particular video, sir. And if at all your friends are in requirement of our classes, sir, they can WhatsApp me on this particular number. We will definitely be very, happy to help them, sir. So thank you very much. फिर मिलेंगे चलते चलते, sir.